Now the world decided to be a signatory of TRIPS, India being party to it, had to change its statute in its backyard. So in the year 1999, you would find that the Copyright Act of 1957, the Trademarks Act of 1958, the Patents Act of 1970 were amended wholesale. And in addition, another statute came in 1999, which is now known as geographical indications. Immediately after that, in the next year, 2000, 3 more statutes, specialized statutes for intellectual properties were introduced. They are known as Designs Act of 2000, Integrated Circuits Layout Design Act of 2000, and another important act called Biodiversity Act of 2000. Immediately thereafter, in 2001, another act was introduced into the category of intellectual property that is known as Plant Variety and Farmers' Right Act of 2001. Now, more or less, these are all intellectual property, but India thought fit to create special statutes because the TRIPS agreement gave the choice either to bring amendments into the regular statutes or to create a specialized statute which is called as sui generis. India opted for sui generis and created these specialized acts to take care of intellectual property of specialized kind. I'll explain all these to you. But let's see first the conventional ones. The first one is copyright. Now, to understand what is copyright and how does it become a property, the Copyright Act says that the copyright shall exist and subsist into 6 categories of expression. And mind you, the Copyright Act applies on expression, unlike patent and trademark, which applies on thought, idea, and concept. Copyright does not apply on idea. You cannot copyright an idea. You have to have an expression in the form of a novel, story, drama, literature, music. That expression can be copyrighted, not the idea. Idea can be patented. The expression can be copyrighted. So the Copyright Act puts 6 categories to the expression. The categories are literature, music, drama, art, and now cinematography and sound recording. These 6 expressions can be copyrighted. And to tell you that sometimes all 6 expressions are copyrighted. For example, if you want to copyright a cinematograph, which includes a story, that is to be copyrighted in the category of literature. It also has music. It also has songs, lyrics. It also has drama. It also have sound recording, and it also consists cinematography. So 6 categories are copyrighted. And mind you, that there is a possibility that the owners of these copyrights can be 6 different persons. Because somebody who created music will be the owner of the copyright of the music. Somebody who wrote lyrics will be the author and thus the owner of the copyright of the lyrics. The one who's producing that cinematography, being the owner of the cinematograph, will be the owner of the copyright of that film. And so on and so forth. So these categories may have one copyright owner or maybe different owners. And that is why when that property is utilized, exploited commercially, then you have to take license from the owner of the copyright holder, from the owner of the copyright or the copyright holder. And suppose if a product is copyrighted under the ownership of 6 different persons, you will have to obtain the license from 6 different persons, different owners. Now, sometimes the owner of the copyright, understanding these nitty-gritties, assigns the copyright to another person. So under section 18 of the Copyright Act, there is a concept of assignment of copyright. Now this assignment can be permanent, can be temporary. The assignment can be for a particular period, and suppose in the contract of assignment there is no period mentioned, then it will be presumed that the assignment is for 5 years. Section 18 of the Copyright Act deals with assignment. Now, contrary to assignment, section 30 talks of license of copyright. Now, please understand these are 2 different concepts. Unlike assignment, the license of copyright is the concept where the right itself is not handed over or not transferred. Simply, a limited interest is approved or permitted. I'll give you an example. Suppose you are a broadcasting body. You are some television channel who want to exhibit a cinematograph. You have 2 options. Either to get the assignment of the copyright from the owner, and then once you have assigned that copyright for a particular period, for 5 years or for whatever period under the contract, during that period you can exploit that property. But against that, suppose in your college you want to organize, and somewhere you read some good story which you want to adapt it into a drama. You don't want assignment of the whole copyright for you. You simply seek a license that can we adapt this story into a drama and perform it in our college. There you are not having the entire copyright in your name, simply a license for adaptation of that story from the author of the story. And once you have a license at a consideration, at a price, you are not violating any law. But in case, if you exploit the property, either the copyright or adaptation, translation without any assignment or license, then what you are doing is violation of that right, which in copyright, in intellectual property terms is called infringement. Infringement of the copyright, and it has consequences.